Okay, can I suggest that we make a start? It's just past 5 o'clock and we've got a tight schedule. So I would like to crack on and introduce our speakers. First thing, this session is being recorded, so we will assume that everyone who's taking part consents to that. And if you don't want what you say to be recorded, then don't say it. And please, can you put your mics on mute while the speakers are talking? We're going to take questions at the end, and we'd ask people to put the questions in the Q&A because it's easier for us to coordinate them. So I'm just going to introduce the speakers quickly. Both Daniel Clark and David Carter are very experienced, predominantly housing and public lawyers. So I think that will be the slant, but this, as you know, is about out-of-hours applications, generally, some do's and don'ts. And I hope that at the end we can have a good exchange from, solicitors and barristers, good and bad practice and experiences. I'm not going to say very much about the speakers, except that they are both incredibly experienced. I know David better than Daniel because I worked with David for nearly 10 years at North Islington Law Centre in the old days, when I would say, I think one thing that's changed is that things are more urgent and more desperate. So when I was at the Law Centre, urgent meant something that had to be done in the next couple of days or this week. And my feeling is just that the levels of destitution, the levels of urgency have dramatically increased, and the levels of stress that we all suffer. So hopefully we can have an exchange about how we do this sort of work as well as we can without breaking the rules. So Daniel's going to speak first, and I'll hand over to him. Thanks.
Thanks very much, Diane. I'm going to, broadly, the division of labour between me and David is going to be me speaking about when you might be making out-of-hours applications, and then David will go on to look at how you actually do that, where that's appropriate. Ray, if we can just go to the next slide, please. Before I start, we've set out on, at the beginning a list of key materials, and these are really the bare bones, but you'll be aware probably there's a new practice direction 54B addressing urgent applications and interim relief specifically. It's quite short. It's a good, helpful, if slightly unnerving summary of the requirements for making those kind of applications, and it collects together in one place a lot of the things that we'll be discussing in this presentation. Of course, the Admin Court Guide look in particular at chapters 15 to 17, which deal with urgent matters and interim relief. I've put there the relevant forms you're going to need in 461 and then 463. Do check that you've got up-to-date versions. In particular, the new versions that came out last year are quite substantial changes. So if you've got kind of old precedents folder somewhere, make sure that you're not using from there. In particular, the N463 is one that you really need to get right. The out-of-hours application form is generally going to be more relevant, I think, to counsel who'll be drafting that, but it's worth bearing in mind what information it is that they're going to need. And then I've put there the kind of now slightly expanded house of horrors in terms of cases about when you shouldn't be making out-of-hours applications or how you shouldn't be making out-of-hours applications. And the test that's the high hurdle that's required. I'll come back to Laura, Hamid, and to some extent to DVP, which is the latest in the series of hard luck tales. So yeah, I think those are key materials which, if you're not familiar with any of them, you should make yourself familiar before you find yourself in a situation where you're trying to make an out-of-hours application. Next slide, please. So part one, my part of the seminar I've called When to Make an Application Out of Hours, brackets, or How and Why to Avoid It. And that really is going to be the key focus of what I'm talking about, is the high threshold that has to be crossed in order to justify making an application out of hours, and really the steps that you need to go through, all the other possible ways of dealing with the matter before you can satisfy yourself and ultimately a judge that it's appropriate to make an out-of-hours application. Next slide, please. So in thinking about urgent applications, I think it's quite helpful to start by thinking about what happens if you just follow the normal course, because any urgent application, with out of hours being at the most extreme end of that spectrum, is a departure from the usual judicial review timetable. So your usual timetable is going to be a decision, a letter before claim in good time before the claim, the action protocol says. You're then going to have to wait for a response, which the protocol, I've put 14 days there actually. There's a caveat to that. The protocol says usually 14 days would be appropriate, but sometimes a longer period and sometimes a shorter period. And you often get defendants saying, we're entitled to 14 days on the protocol. Well, actually, you're not. You're entitled to a reasonable period, which generally may be 14 days. You then have to issue the claim, obviously, promptly and no more than 3 months from the decision. And that is the usual stage at which applications for interim relief should be made, that they're made usually in the N461, or if you've already issued a claim, you make them in a separate N244 application form. You then got 21 days from the service of the claim for the defendant's acknowledgement of service and summary grounds, and you then will have a permission decision on the papers thereafter. The latest edition of the Civil Justice Statistics shows that the average time from issue of the claim to a decision on permission on the papers is 74 days, so 2.5 months. That's before you get a decision on whether the claim can proceed. And at that stage, you will usually get a decision on your interim relief application if you've not taken steps to expedite it. You then may have an oral renewal hearing if you've been refused on the papers, and then you'll be heading towards a final hearing. I was surprised in a way to see that the Civil Justice Statistics say that on average, it's 101 days from issue of the claim to final hearing. Certainly, in my experience, it can be a lot longer. But then I suppose that's also going to include some of the expedited claims that are going to bring that average down. So at least 3 months generally, but often a lot longer. So that's the timetable that you're going to depart from if you need to. Next slide, please. The other thing to think about before we get to urgent claims specifically is the test for interim relief. It's worth noting, because there's been some recent development on this. You'll be very familiar with judicial review cases generally. The court is effectively applying the American cyanamide test of whether there's a real issue to be tried and where the balance of convenience lies. And that has been applied in the judicial review context by medical justice cases and others. Bakongo, I think, springs to mind. It's worth noting the principle that's been summarised in the admin court guide, which is it's very easy to think, well, you know, what's this one particular decision? If interim relief is granted in this particular case, for the public authority, it's just one more person they're accommodating, and that's not a huge prejudice to them in the way that it might be in private litigation between private parties. But the authorities share, as is noted in the admin court guide, that the courts have to take into account the general public interest in public authorities' decisions remaining pending a final hearing. And so you can't just fall back on a kind of approach that this one decision is not going to cause significant prejudice to the public authority. So that's JR cases generally. In relation to applications for orders for accommodation by a local authority, in DeFalco and Crawley, the Court of Appeal said that it was necessary to demonstrate not just a real issue to be tried, but that you have a strong prima facie case that the decision under challenge is unlawful. And there has been, I was kind of drafting pleadings on this basis for a while, and then there was a case of Knowlson and Stevenage where it was argued, but ultimately no decision made. The argument was that, in fact, DeFalco and Crawley had either been overtaken by subsequent authority, including Jamaica Bank and Olint, or had been decided per incuriam, because the court hadn't taken into account certain relevant authorities. That seems to now be settled against claimants for the purposes of the High Court in a case called Cadet. It was actually, the decision in Cadet was Hugh Southey sitting as a deputy judge, deciding against the argument that he himself had run in Nelson. But anyway, he said the authorities are binding for now. This may need to be revisited in future by a higher court. So it can be worth putting that argument in your case so that you reserve your position for later. But effectively, you have to proceed on the basis that you'll need to show a strong prima facie case. Next slide, please. So, in terms of the theme of my part of the presentation about how to avoid going out of hours, the next thing I want to consider is how you might deal with cases urgently, i.e. to depart from the normal JR timetable that I've set out, but without ending up going to the most extreme option of an out of hours application. And I've listed these in more or less in order of increasing urgency. So the first thing that you might do is abridge the time for a reply under the pre-action protocol. You might, and particularly if you've got a limitation or the 3-month long stop limitation coming up, you might say to the defendant, well, actually, usually you might get 14 days for this, but actually we think it's appropriate that there should be 7 days for a reply. That obviously is going to be relatively limited expedition considered in the context of the judicial review timescale as a whole, but it's an option. As is, I've mentioned there, an agreement on limitation. So if the reason your case is urgent is because there's the 3-month deadline coming up, you can agree with the other side that you'll give them longer to reply to the pre-action protocol letter if they don't take a point on time limit. It's worth noting there that, strictly speaking, the rules say the parties can't extend the time to apply for judicial review, but there's a footnote to the pre-action protocol that says that the court, if the parties have agreed it in order that pre-action correspondence can be carried out, the court will take that into account. You may decide that you want to issue a claim form protectively and have it stayed. So that's kind of the least urgent procedures. Where you've got a more substantive issue of prejudice, particularly in housing cases where clients are going to be without accommodation, the parties may disagree about whether or not the judicial review is well founded, but it's not unheard of, at least, for defendants to be persuaded that even if they don't accept that the judicial review is made out, that they should agree without prejudice to that position to provide interim accommodation pending resolution of the judicial review, in order that a application for interim relief doesn't need to be made. So if you have a sensible, pragmatic defendant, they may say, well, look, we don't think our decision's unlawful, but rather than us all rushing off to court very urgently, we'll accommodate until the judicial review's heard. Or even, in fact, to avoid an out of hours application, you could be asking, will you accommodate for 2 weeks while we, or 3 weeks or 4 weeks or whatever it might be, or even just overnight, so that we can get an application for interim relief in on the papers rather than having to go out of hours. Other options are expedited directions. So it might be that things are urgent, but you could, accommodation is going to come to an end in a matter of weeks or months. So you need the claim heard by then, but not necessarily before then, and you can do that by way of expedited directions. And then at the most extreme end, before out of hours, you can get urgent consideration of an application for interim relief on the papers, even within a couple of hours and even before you've issued the claim. So yeah, really that leaves out of hours reserved for only those cases where you can't wait until the court can decide the application on the papers within court hours. Next slide, please. So wherever you're using the more urgent end of the scale, you're also going to need an N463 form requesting urgent consideration of your applications. Whether you're an out of hours application, you won't necessarily, but if you're having an application for urgent interim relief on the papers, or for expedition of the claim for the acknowledgement of service, you'll need an N463. It used to be the case, I mean, certainly even the admin court guide itself suggested that you needed an N463 wherever an expedited judicial review was required. So if you needed a hearing before the 101 odd days on average that it took, it was understood relatively widely that you would need an N463. There's recently been the case of an application for judicial review, in which the court issued a practice note saying that you only now use an N463 where you need urgent interim relief to be considered, or where you want to abridge the time for acknowledgement of service. If you just want expedited directions beyond that, then the appropriate way is not to fill out an N463, but rather to make a NT44 application and put in a covering letter saying to the admin court office that you need it considered quickly, but not within the N463 timetable. In relation to the N463 itself, as I said, the form's changed last year and requires some more detail, really, than the previous version, or at least spells out the detail that's needed. And the key case here to look at is DVP, because that's a case where the court hauled the legal representatives in for telling off for not having used the N463 procedure properly. And the form requires the claimant to put in the reasons for urgency, the justification for the request for urgent consideration, including any explanation of any delay. And that's important because even if you've got an urgent matter, if you've sat on it for a few weeks or even a few days, the court may say, well, actually that justifies the refusal of relief. You then have to set out whether you're requesting consideration within 3 days and specify a number of hours, or 3 to 6 days. You then set out your requests for consideration of interim relief, abridgment of the acknowledgement of service, a permission decision and final hearing, and the timescales that you want those in. Then your grounds for the application for interim relief, or whatever it might be, and a draft of the order sought, and then details of when the application was served on the defendant, and a statement of truth. And that used to be a bit unclear, I thought, whether it was from the solicitor or claimant, or whether it came from the advocate. And it's now clear that is a statement by the solicitor or client. The key points from DVP really are that you have to complete the whole form, and you can't just cross-refer to other documents. You can't say, see the grounds, or see the witness statement of. You have to, the N463 has to be a standalone document which summarises your full case on interim relief, and that's quite difficult actually, because you've got limited space, and usually always the strength of your grounds are going to be relevant to showing you've got the strong prima facie case. So it's really an exercise in reducing down your claim to the bare essentials and showing why it's urgent and why you have a strong case. Duty of candour is particularly important in the context of urgent applications. That's been made clear in a number of cases, but DVP is the latest in the line. And wherever possible, even though your application won't be on formal notice, the court will want to know what the defendant's position is, unless that's really just not possible in the timescale. So where the defendant needs to be put on notice informally of the application and given an opportunity to respond ideally, and then that response should be put before the court, so the court has at least an indication of the defendant's position, even though that doesn't lessen the duty of candour on the claimant. Next slide, please. This is a cautionary slide about the abuse of procedures. There's now a number of cases, as I say, DVP, the latest in line. The original one really was Hamid, in which the court said that if you improperly use the N463 procedure and the out of hours procedure, then we will summon you to court, and you will be able to explain yourselves, and it will be an open court, and you will be named. And yeah, I won't dwell on that. It's been the case for a while, and I would just say, if you haven't looked at them already, have a look at the cases, Hamid and DVP particularly. And also there's a summary in the admin court guide of cases where that Hamid procedure has been invoked. So it's worth having a look at those. Next slide, please. Next slide, please. So here, just a summary of the duty of candour. Again, I won't spend very long on this because I've not got a huge amount of time, but as you'll be well aware, claimants under a duty to make full disclosure to the court of material facts known and impediments to the claim. So that includes the full range, including alternative remedy, delay, adverse case law, statutory ouster, and change of circumstances, and that's a continuing duty. The fact that the defendant has an entitlement to file an acknowledgement of service doesn't change the duty of candour, and that's even more so in circumstances where it's an urgent procedure and the defendant hasn't had proper opportunity to respond. And that point is reinforced in 15.23. Next slide, please. So here then I've set out from Laura and Restormal and Interroute the particular duties relating to applications for interim relief without notice. And in law, the key points really are: there's a duty to make a full and candid disclosure of material facts known, including facts that go against your case. But there's also a duty to make proper inquiries before making the application. And so it's no good saying, oh, well, we didn't know that there was possible alternative accommodation available for the client if you never made the inquiries that would have allowed you to find that out. And also, again, the proper disclosure for this purpose is specifically taking the judge to documents and passages in documents and ensuring that the judge understands it. So there's no hiding any bad points in an application. Second point, which comes from, I mean, this is not a judicial review case, but the principle applies in out-of-hours applications, that there's a requirement to make a full note of the hearing during the hearing or as soon as practicable after, and to provide that note to the other parties with all expedition. And that applies, you don't have to wait for a request for that note. Counsel should be making the note, or the solicitor should be making the note if they're in on the hearing, and then that should be provided. Next slide, please. So as a conclusion, when do you go out of hours with an application for interim relief? And my answer is never, if you can possibly avoid it. And that sounds rather negative, but really, if you take that mindset, then you'll make sure that in those cases where you do have to go out of hours, and there will be some, you're in the strongest position to explain to the court why you're justified in doing so. The court's answer in the admin court guide is kind of perhaps more helpfully, that you go out of hours when an urgent application needs to be made outside the sitting hours of the admin court, and the application cannot wait until the sitting hours recommence. And legal representatives must consider very carefully whether an out of hours application is really required, and only should make that application if it can't wait till the next working day. So I've just finally set out 6 questions that I think you should ask yourself, both solicitors and counsel, before deciding that an out-of-hours application is appropriate. So first of all, is your case strong enough, bearing in mind the duty of candour? Because no matter how sympathetic the circumstances of the client, if you can't demonstrate that you've got a strong prima facie case, even after you've taken the judge to the points that go against you, then you can't properly make an application. Second, even if you've got a strong prima facie case, what prejudice is going to be caused by waiting until 10 a.m. tomorrow? So will the client be street homeless? And some of these questions seem very harsh, and I've had an out-of-hours application where I said to the judge, well, look, I do need to tell you that the client won't actually be literally on the streets; they're going to be in a car overnight. And the judge has said, I'm not going to leave your client in a car overnight. And I said, okay, fine, but I need to point that out to you, because that's really the level of prejudice that the court's going to want to know about. Will they be street homeless? If they're going to be street homeless, is it for the first time, or have they already been street homeless for 3 weeks, or for 6 weeks, or for 3 months? In which case, it might be more difficult to justify an application. Are there any particular vulnerabilities? For example, are children present, and are there any other risks? So once you've demonstrated to yourself that you've got a strong enough case and that there's strong enough prejudice that you might be justified in going out of hours, can you avoid the prejudice without going out of hours? So the key one, I think, really is, has the solicitor spoken directly to any friends and family about one more night? Because often cases have come to me where the solicitor said, client said they've got nowhere they can stay, they have to leave today. And I've said, have you spoken to the family directly? The solicitor gets on the phone to them and says, look, we need you to accommodate until tomorrow, and then we can make an application on the papers. And the family's gone, oh yeah, go on then. I mean, I don't really want to, but if that's, if I have to, I'll do it. Are there any other options? And again, the duty of inquiry is important there. And the flip side to that question as well is, it might be that the prejudice can't be avoided without going out of hours, but then you have to ask yourself, can you avoid the prejudice even if you do go out of hours? So what relief are you going to be seeking? Is there an order that the court can make which will stop that prejudice? And if so, are you able to put it into effect tonight? Have you got a contact number for somebody at the council who's going to be able to provide accommodation at 10 o'clock when you get your order? Because if not, again, it's going to be difficult to justify going out of hours, because you will have taken up the court's time to make the order, and it won't actually be avoiding the prejudice you're talking about. And then finally, what attempts have there been to notify the defendant, and what are the reasons for any delay? As I say, the court's going to want to know the defendant's position, even informally. And even if you've got a case that's strong and there's prejudice, if actually this decision's been known about for weeks, and steps have only been taken at the 11th hour, then again, you might have difficulty persuading the court that they should grant interim relief. So, having run slightly over time, I'm going to finish there and hand over to David, and then we'll take questions at the end.
Thanks, Daniel.
Sorry, I'm just having difficulty unmuting myself.
Over to David. Unmuted David.
Right. Thanks, Dan, for setting the legal framework. I'm going to start. Can I have the next slide, please, Ray? Start with just a word about funding, which is always important. And there are two principal points. The first is that the legal aid provider can only delegate functions on judicial review in very limited circumstances, and under the following statutory provisions. Any provision of Part 7 which is judicially reviewable is within the exceptions. So, for instance, I mean, not all Part 7 functions are judicially reviewable, but for instance, a failure to accept an application, failure to provide interim accommodation before determination, failure to exercise a discretion properly after the original decision has been made. Those they cannot be subject to an appeal, so they are judicially reviewable and they come within Part 7. So therefore, a solicitor can delegate functions. Section 21, National Assistance Act, duty on local authorities to accommodate adults. Section 20 of the Children Act, duty on local authorities to accommodate children in need, but it doesn't include Section 17, and quite frequently the complaint is under Section 17 of the Children Act, in which case you cannot delegate functions. Section 47 of National Health Service Community Care Act relates to the duty to carry out assessments and to provide accommodation prior to a full assessment. And finally, Section 19 of the Care Act 2014 is the power to meet care and support needs for adults. So unless you can bring the claim within one of those statutory provisions, then you're not able to delegate functions, and therefore you won't get paid for the work you've done, and nor will counsel if instructed. There is a link there to the regulations which set it out much more fully. Second point to make about funding is that, as I think everyone who's in this webinar knows, you generally cannot get paid for judicial review work, that's either solicitor or counsel, unless you're granted permission. But there are exceptions to that, and they're set out below. Importantly, for the purposes of today's webinar, they do include applications for interim relief. So any work you carry out in preparing a witness statement, in making an application for legal aid, instructing counsel on an application for interim relief, such as an out-of-hours application for an injunction, is covered by legal aid. Next slide, please. Yeah, I think what I'm going to say here is will probably overlap with what Dan has already said. I'll try not to repeat it. The first point refers back to the 6 questions, which are the last slide of Dan's talk. And it's important to consider those 6 questions almost continuously, because things can change very rapidly. I mean, typically, a solicitor will become aware of the need for an out-of-hours application probably at some time during working hours on the of that day, and it is important that you keep in touch with your client almost continuously. Now, most people these days seem to have mobile phones, and so in theory it should be easy to contact them and the client to contact the solicitor. But clients are not familiar with the duty of candor, nor is it necessary for them to be so. They will understandably do things which they feel are in their own best interests. So you may have been told at 4:30 that there's absolutely nowhere for your client and her 3 children to go. So at 4:30 you contact Chambers, you speak to a barrister and talk about it. The client, meanwhile, has met her friend, and her friend has said she can come and stay with her for that night, or something like that, and doesn't think it's necessary to contact the solicitor to tell them of this, because after all, she's now got accommodation, which was the problem before. You need to know that right up to the point at which the application is made. And so it is very, very important for the solicitor to keep in touch with the client and vice versa. I mean, I had a case where my client, who was a single parent with 1 child, had been sent up to Birmingham by a London authority, and when he got there was no accommodation available for him. This was meant to be interim accommodation provided in Birmingham to someone who lived, I think, in Brent. And I was instructed that afternoon, and and unfortunately that night there was a long queue of people waiting to speak to the duty judge, and I didn't get the injunction till after 11:30 that night, by which time the client had found somewhere to go to. And that, I mean, that wasn't anyone's particular fault. He was on a train from Birmingham back, but because he got a return ticket. But it just illustrates the fact that had I known at the time that I was making that application, then I wouldn't have made it. In fact, what we then had to do was to apply to the court the following day to be released from an undertaking. I'll come back to that at the end. So constant contact is really necessary. The second point is for the solicitor, if possible, to speak directly to anyone who might assist. Now, it doesn't mean everyone in the world, but the client may have been kicked out by a family member or a friend. And in circumstances like that, it really is very sensible to try and speak to that family member or friend. And bear in mind that often the local authorities do just that. So you write your letter before claim, perhaps seeking a response within a couple of hours. And the response that comes back is that the housing officer phoned up Mrs. X, who said that your client could stay for just 1 more day. So it's worth you doing that to make sure that something like that hasn't happened. Speaking as a barrister, it is greatly to at the advantage of everyone if you get to us as early as possible. I appreciate that these things often come in at the drop of a hat, but even if the client has just come in and you haven't got full instructions, it's well worth talking to the barrister you perhaps will instruct, just to get an idea about whether there is any possibility of there being a judicial review claim, and whether there is any merit in making an application out of hours. Further down the line, you're going to need to decide between you how you're going to divide up the 60 minutes or so you've got left to try and progress the claim. I've already dealt with point 4, keep in touch with the client. As Dan said, it's very important to find out if there is someone in the defendant's organisation, likely to be a local authority, who can deal with the matter after whatever time the phone lines close in the department you're dealing with. Now, in my experience, and I deal mostly with London authorities, and or I can say all London authorities that have out-of-hours services. Some contract them out, but indeed most out-of-London authorities are out-of-hours services, an out-of-hours service, but you need to get a telephone number, which, because if you get your injunction, you're going to have to contact someone in the defendant's organisation. And it's a question the judge will ask the barrister early on in the application. I'll come back to that in a moment. And the last and important point is that if you do proceed to apply out of hours, then as counsel, you will be required to give an undertaking on behalf of your client to issue the claim, usually within a very limited time frame, and to pay the fee. So you need some instruction to give counsel instructions on that. Next slide, please, Ray. Yeah, I don't think I need to spend too long on this. The new guidance issued after DVP said that there needs to be a separate bundle when you're applying when you're applying for urgent consideration. And it may well be that if you get your out of hours injunction, part of the order made by the duty judge is that you have to make an out of hours application in form N463, and you'll need a bundle to go with that. Next slide, please. This is actually after the hearing, but I do want to say something about the hearing itself and just the process of getting in touch with a judge. I mean, in many ways, it's quite an amazing system. It does enable you to have a hearing in front of a High Court judge at very short notice. The procedure, which is set out in urgent applications in the White Book, is essentially that you phone the High Court and speak to the security on the front desk at the High Court and tell them that you want to make an out of hours application. You've got to say which division of the High Court, and it's the QBD, the admin court is in the QBD. You get quizzed then by the security guard who'll ask who you are, you know, probably, and we'll want a contact number, and also we'll want to know what chambers you're at. He then, or she, contacts the clerk to the duty judge. The duty judge could be any one of a large number. The Queen's Bench Division is the biggest division in the High Court, and at the last count, there were at least 50 judges. Not all of them have any knowledge or skill, or they have knowledge, but they have any particular expertise in relation to administrative court claims. So there is a rota for the duty judge. So you could end up making application before someone who's never done a judicial review in their life or never appeared as counsel in a judicial review case. So you may well be, you have to be prepared to argue the case as if it was an application in open court. Anyway, the duty, I always get the name of the judge from security so that I know what sort of judge, I get some intelligence on the judge that I'm going to have to make the application in front of. The security officer then contacts the judge's clerk, and this, in my experience, is probably the biggest hurdle you face, because the judge's clerk is like a gatekeeper for their judge, and they will almost certainly ask you why it is urgent. The judge will also ask you this at a later stage, but the judge's clerk will quiz you. And I've had cases where it's been more difficult to get past the clerk than it has to get the injunction from the duty judge. The judge's clerk, you will already have made your paper application, which the judge's clerk should then have. He or she may well ask you for further documents, and these days it's relatively easy to scan documents and get them through, but things like letters before claim, if you've had the opportunity to draft an order, then or any other documents, then it may well be that the judge will want to see those. You then sit back and wait, and at some stage you'll get a phone call from a judge, because the judge always phones you. And as I said in that example I gave a moment ago, if you're unlucky, you can be there all evening waiting for the judge. Now, in the meantime, it's essential to keep in touch with the solicitor, and the solicitor to keep in touch with the client, so that everyone knows what everyone else is doing. When you finally get through to the judge, the first question that the judge will have will not be, what is the strength of this case? The first question will be, why is it urgent? What do you want me to do, and why is it urgent? The next question is, well, where, if I make the order, how are you going to communicate this to the defendant? So, and then you'll finally get onto the merits of the claim. But urgency and the need for the injunction are key at in the front of the judge's mind. During the hearing, you have to take notes to conform with the requirements of the case that Dan referred you to, the briefest notes. The judge will almost certainly want to tinker with your order, and they come in very different forms depending upon the judge. Some want to know the name of the solicitor, put that in the order. They record the time that the injunction is made. You have to give an undertaking to issue, usually within a very short time. In my experience, usually by midday on the following day. Sometimes you're lucky, you can get it till 4 p.m. But that means you're often going to have to continue work that evening, both solicitor and counsel, perhaps solicitor to draft a witness statement, counsel to draft the grounds, in order that it can be issued the following morning. I can't emphasize enough the duty of candor. It's Dan's already told you about it, but it may interest you to know that there is the current administrative court judicial review guide makes provision in it for a Hamid judge. And a Hamid judge is the current one is Mrs. Justice Tipples, and her job is she is there if the court believes there's been an abuse of the emergency procedures, and in which case both solicitor and or counsel might be hauled up in front of the Hamid judge to explain why they took the action they did. Right, well, after the hearing, clearly you'll want to contact the client to tell him or her what's happened. There's still quite a lot of work for the solicitor to do, because normally the last thing that I would do as counsel would be to send an approved order through to the judge. or send a judge an order for him to, or her to approve. Sometimes you get a signed order back, other times you don't. And the judge just says, well, you can tell the local authority or whoever it is from me that the order's been made. In most cases, local authorities take that seriously and follow it. But clearly it's better if you've got actually a signed order, and the tendency these days is to get a signed order back. That's got to be sent off to the solicitor. The solicitor has to contact the client and contact the defendant and find out where the defendant is going to provide, if it's accommodation, where they're going to provide it. Then you've got to issue, and the slide assumes it's the next day because it almost always is, and you've got to then comply with that. Now, if it says the claimant undertaking through her counsel to issue the claim by midday on the next day, then you've got to stick to it. And if it's past midday, you're in breach of an undertaking. If there's any reason for a delay, then you have to apply to be released from the undertaking. And that means effectively going back to the judge who granted it, the judge's clerk, and putting forward reasons why you should be released from the undertaking. I would have to type up my note of hearing, send it to my solicitor, who will then send it off to the defendant. And at that point, you've now got an injunction from a High Court judge. You're very much in the box seat. It is well worth trying to settle the matter at that stage. And again, in my experience, most of these cases, whether they're social services or housing, really the only point of the claim is to get that emergency accommodation. Once you've succeeded in that, there is often no point in going further with the claim. So it's a question of settling it at that stage. Right, I think that's all I want to say on it. Diane.
Thank you very much, both of you, for really detailed, practical presentations. We do have some questions. So if I could earn my keep as chair, I would read these out so that everyone knows what they are, because we're the only ones who have access. So there's a question from Chris Walton of Shelter, who is saying Shelter's got a hardship fund which can be used to pay for overnight accommodation. The question is, how is that likely to play out in terms of the duty of candour and the urgency, where someone would be street homeless but for the use of the fund? I don't know which of you want to try and tackle that. Maybe Daniel, you might have seen the question a bit earlier than David did.
Yeah, I mean, I saw it and I thought it was a very good question, and it's a difficult question. I'm not aware either in reported authority or in my own cases, I don't think, of any decision on a similar point by a judge. I think, I mean, it's difficult because obviously if the availability or the existence of that fund were a bar to relief, then Shelter would almost never be able to do it. And indeed, other solicitors may not be able to if they could go to Shelter and say, look, can you use the hardship fund? I mean, I think probably the answer would depend in part on the criteria that Shelter have for the hardship fund. I mean, if this is a fund where the individual client meets the criteria, then that would clearly be relevant. I suppose Chris's answer is going to be that it's an exceptional fund, and so there are no defined criteria. I mean, I think I would probably, in those circumstances, want to have an explanation to go before the judge about why the hardship fund wasn't being used. And I think if it's there generally, then I would be tempted to say that fund should be used if possible, in order that an application can then be made within hours the next day. And I certainly think that defendants shouldn't be able to rely generally on saying, well, look, you should just be paying to accommodate these people. but yeah, I can see that it may be a difficult balance to strike, and I think for the sake of one night, if it's possible to use the hardship fund, that might be preferable to all the risks of going out of hours.
Can I add to that? I agree with Dan, and I think there are two issues. The first is the duty of candour, and I think you have to disclose it because it is a possible way out. But then if you're not going to spend the money, you have to explain why. So, yeah.
Thanks very much. An anonymous question is about if solicitors do make direct contact with friends or family to find out if they can accommodate, would you ask the solicitors to do a witness statement to accompany an out-of-hours application to set out the steps they've taken to make those inquiries?
I don't think that's necessary. I think you should. I think there usually isn't time to do that anyway, and I think it's good enough to tell counsel, and that can be relayed to the judge.
Yeah, I mean, I think that's probably right. In circumstances where you're making out of hours applications, you're probably going to be hard pushed. I think, you know, certainly if there was any degree of complexity to it, I would want maybe an email setting out in detail, just an email from the solicitor to me saying these are the steps that I've taken. So at least I've got a record of that, and I can make sure that I'm passing accurate information to the judge. If it was a case where there was some particularly tricky factor and there was time to do a witness statement, then great. But I agree that generally, as long as there's kind of very clear instructions about what's happened, then the judge will usually take that from counsel, albeit that you might then be putting in a witness statement when you're issuing the claim, because there may well be a return date on notice about interim relief, and at that stage it might be appropriate and useful to have a witness statement.
Thanks very much. Daniel Rourke is asking a question which I suspect is not one that you'll be able to answer, but maybe people who are here who are solicitors might be able to, might be wronging you. But Daniel asks if he can check the practical steps required to grant funding under delegated powers and the single and dual stage procedures on CCMS. And the question is about whether the question on the forms about whether delegated functions have been exercised, and do we need to record separately the grant of delegated functions in a file note, and how much detail is required. And just as a flavour for the two barristers, this is what we have to do.
I was going to say I'm delighted, and I hesitate to say this because I'm sure it'll earn me the displeasure of all the solicitors in the audience, but I'm delighted to say I've never seen CCMS in my whole life, so I'm not going to be able to help with that, but I'm sure there may well be solicitors in the audience who could post in the chat and share
that's what I was going to suggest, because it's something that many of us have dealt with, and it may be that somebody could give Daniel some tips on that. We're nearly out of time, but I just wanted, if I could abuse my position as chair, to ask a question which I was slightly surprised, David, that you said all London local authorities have out-of-hours services, because my experience is that they keep them very secret. And I just wonder, it seems to me one problem that someone pointed out to me before this session is getting hold of someone in the local authority, not just out of hours, often within working hours, getting through to the right person. Is it the homeless persons unit? Is it legal? Can you get to speak to anyone in legal who will talk to you? I just wonder if it might be a good idea tactically for anybody who's doing applications on a regular basis against particular authorities to write a formal letter to head of law or the homeless persons unit director to say, look, what is the out of hours service? Please give us details of how we can contact you out of hours. Because then if they either ignore you or come back and say, well, it varies, or go on the website, that's presumably some evidence that might be helpful in an out of hours application if it's not been possible to get hold of someone in the local authority.
Well, it might be. It's usually social services who run it on behalf of them and housing in unitary authorities. I mean, I haven't come across a case where we haven't been able to contact someone, and it has. What happens? You get in touch and they say, "Oh yes, we've got a note from housing never to house this client," or whatever. You know, you get something like that, but you're not going to talk to someone who's got any particular understanding of the case. But yes, I mean, I think it's not a bad suggestion you make, but I haven't come across a case where we haven't been able to get in touch with someone. It's taken some time, but
yeah, I mean, I think there were potentially there were two issues. One is about whether you can get whether your pre-action, your kind of informal notice, is going to go before anybody who's going to give you a reply. And the other is whether you can get the order put into practice. And I think most places will have some kind of out-of-hours service for providing accommodation, even though they'll be staffed by somebody who knows nothing about the case. And then I suppose the position that you're in is that you ring them and you say, look, you don't know who I am. We've been trying to get in touch with your department all day and everyone's ignoring me, but we've now got an order from a High Court judge saying you have to accommodate. So you have to accommodate. And hopefully at that stage, any local authority who knows what's good for them will comply, and they'll hopefully you'll have an order, or they'll accept your word as a solicitor. And if they don't, then obviously you're in the territory of applying for penal notice or steps to commit, that kind of unseemly territory. But yeah, I agree with David. I don't think I've certainly had lots of cases where local authorities don't reply at all to the pre-action stuff.
Yeah, I think that's what I'm referring to more, is it's so difficult often to get anyone to engage because it's not yet been allocated, because they don't know about it. And I just think in terms of maybe heading off a criticism that you haven't got a response, it might be a very good tactic.
No, I agree in relation to that, because I mean, to some extent you think, well, we send the pre-action correspondence to the local authority. It's their problem if they haven't got services, they haven't got systems in place to get it to the right person. But actually, I think as a kind of, both as a acting in accordance with the spirit of the procedures, and also to convince a more practically minded judge, it's very helpful to say, look, these are the steps we've taken to try and make sure that somebody at the local authority is actually looking at this pre-action stuff, even on an informal basis. The one thing I'd say on that actually is, for those people who aren't members of the Housing and Immigration Group, they've got an email list which quite often I think has queries of that kind of nature come around saying, has anybody got an out of hours contact, or has anyone got an urgent contact for Nearham or wherever it might be?
I mean, I agree. I've seen those emails as well, but it just occurred to me thinking about this that actually it would be a very good thing to formally ask for information about where that correspondence should be sent. I'm thinking the Civil Justice Council are currently reviewing the pre-action protocols, and the housing subgroup, which I was involved in, recommended that local authorities should be required to publish an email address or a formal address to receive pre-action correspondence. It seems it's even more important probably in urgent JR type issues, where you really need to get someone to engage with you, maybe at 3:30, which can be very difficult. We're having some, not questions really, but comments regarding different local authorities' conduct. Apparently, I think it's better to be homeless in Cornwall, save that you won't be able to get any advice probably. But Newham and Barking and Dagenham, Barking and Dagenham tick, Newham, boo. So there we are. I think we should all do a league table of the performance of local authorities in these matters at some point. We're bang on time, and I'd just like to say a massive thank you from everyone for a great presentation from Daniel and David. There is one final question, which is, are we having the slides sent to us? So
there's one more that's come through on the Q&A, which I think I can deal with very quickly. From an anonymous attendee saying, if your client refuses to give you contact details for friends and family so you can contact directly, would counsel such as yourselves negatively advise to go out of hours? I mean, it's hard to give a blanket answer for every case, but that would be a huge alarm bell, which would make me very, very cautious about going out of hours, put it that way.
I agree.
There's also a good comment from Debbie Howard, which is just to be aware of the fact that you need to advise your client about where they might be placed, and the fact that it might be out of the area is probably not going to be very nice. That's my comment. Debbie's is just that it may be out of area, but it's true. I mean, I've had cases where the client has been appalled at what's been offered at 10:30, and that's for us to be realistic with our clients, I think.
Because there's nothing worse actually than everybody having moved heaven and earth to get this order, and then the client going, "I'm not staying now." And I've had that happen certainly on urgent paper applications where the client said, "Oh, it looks rubbish." And you think, well, yeah, we needed some expectation management previously would have saved a very embarrassing and then quite tricky situation of having to kind of.
Absolutely. Kush has put an answer to everyone, which I hope, Daniel, may answer your question. I feel like I have limited ability to consider CCMS at this stage of the day, and I can't bear to read that out, but I think Kush could perhaps, Daniel, you can read that from Kush in the chat, if you can see the chat. And I hope that's helpful. Thank you. Yeah, I don't know if you've got time for any further questions, but I think we've covered the written questions. And again, I'd just like to thank you both for a really helpful presentation. Thank you.